You may recall that in a SIOSH webinar on the 28th of May 2021, the then Inspector of the Department of Employment and Labour, Mr. Tibor Sana, unpacked the Occupational Health and Safety Act Amendment Bill 2020. I then produced a series of YouTube videos to try and explain the proposed changes. You can view those YouTube videos on my YouTube channel, Delene Sheesby Safety Practitioner. There were many significant proposed changes to some of the sections of the bill, which immediately raised volatile criticism from the industry. As required, the bill was released for public comment, and SIOSH, with the assistance of their members and the technical committee, submitted their combined comments on the bill to the Department of Employment and Labour Chief Inspector Mr. Tibor Sana. If you are interested in those comments, you can access the bill, the OHS bill final, on the link shown on the screen. Inevitably, the draft bill's shortcomings were brought into the spotlight, and then, on the 3rd of September 2022, in a SIOSH webinar presented by Advocate Reynard Luch, the managing member of Claas Luch Associates, labelled it as needing to be back to the drawing board. His view is that the amendment bill is riddled with inconsistencies. It incorporates legal elements in some provisions which are removed in others, and has incoherent penalty schedules and vague definitions. If you missed the webinar, perhaps I can touch on a few items from this webinar. The purpose of the amendments to some of the sections was to ensure consistency with the spirit and provision of the Constitution dealing with right of life, human dignity, right to fair labour practice, access to information, and lawful, reasonable, and procedural fair administrative decision-making. The changes to the Section 16.2 appointment remains a very contentious aspect. The CEO must delegate duties in writing and be accountable for any duties that have been delegated. The CEO has been potentially accountable all the time. In fact, the former Chief Inspector said that we want to look at middle managers, managers, and down to supervisors and give them a role, but unfortunately this amendment bill does not go into that at all. The non-mandatory 16.2 assigning persons and the CEO who appoints them are usually too far removed from the realities of the workplace to properly discharge their statutory duties without managerial and/or supervisory assistance. This has often required employers to resort to so-called in-house appointments like an 8.2i appointment. These in-house appointments carry the same weight in law as they are so-called statutory appointments, since they constitute a lawful order as envisaged in Section 14C of the Act. The proposal to the Department of Employment and Labour was to cover managers and supervisors and to fill that vacuum by introducing a statutory appointment for all those managers and supervisors in the form of a Section 16.3 appointment, save where written appointments are required in terms of regulations, for example, General Machineries Regulation, the GMR2s, and construction regulations. Section 8, General Duties of Employers to their Employees. Most companies and safety practitioners have preempted this, but for some odd reason, reasonably practicable, was retained in Section 8.1, but deliberately removing it from 8.2, 9, 10, 13, and 16. It doesn't make sense. It's in some sections and not in others. A very important addition is the requirement for risk assessment. It starts off by discussing or requiring a risk management plan, which must be developed and implemented by persons who are competent to pronounce on the associated risks and that the risk management plan must be in place and available at that workplace. A very strange change on Section 10.4, which is the general duties of manufacturers and others regarding articles and substances for use at work. This 10.4 section has been completely deleted in the bill. Currently, what it means is that, for example, if you have a piece of machinery without machine guards, which now makes it unsafe, you can sell or give it to a third party, provided that you obtain an undertaking in writing from that person that they will carry out certain requirements to make that equipment safe again. So now, if 10.4 is removed completely, and you have a yard full of redundant, broken, unsafe equipment, before you can sell it or get rid of it as scrap, you will have to spend a fortune on making it compliant and safe. There is no longer an undertaking in writing to make it compliant. But then in Section 22, which is the sales of certain articles prohibited, they say, subject to the provision of Section 10.4, no person shall sell or market in any manner whatsoever any article unless it complies with that requirement. But they deleted 10.4 in Section 22. Don't understand. Then in Section 41, it says, this act not affected by agreements. That means that you cannot, by mutual agreement, bypass the law. The current act says except for 10.4 and 37.2. But now 37.2 has also been deleted. For example, now you can never have an agreement which bypasses the law. For example, the General Safety Regulation 2A, which states that as an employer, you have a duty to ensure the safety of your employees, and that nobody may enter your workplace who is under the influence of alcohol or is intoxicated. So currently, because we can have a 37.2 agreement, you can have an agreement with a contractor or a mandatory, like, for example, a security company, who will ensure that nobody enters your workplace under the influence of alcohol. They will stand at your gate and monitor entrance and do breathalyzers if necessary. But now 37.2 is gone, so you cannot outsource somebody to perform that function. You will have to do it yourself. From a latest presentation presented by the Department of Employment and Labour, they use this slide, the one that you can see in the top left-hand corner of this slide. It's with regards to the definition reasonably practicable. You will know that all the duties in the Act are tempered with reasonability and practicability, and employers shall, as far as reasonably practicable, ensure the safety and health of their employees. In the proposed amendment bill, this definition is totally gone. Are they wanting to hold South African employers to a higher standard than internationally? Or perhaps they want to introduce what seems to be strict liability, which is consistently rejected by the criminal and constitutional courts and infringes negatively on the rights to a fair trial. Even the ILO C155, which is the Occupational Safety and Health Convention 1981, Article 4, of which South Africa is a signatory to this convention, refers to the term so far as is reasonably practicable. So now with this deletion, if an employee has an accident, someone will be punished. Nobody cares if you did what was reasonably practicable or not. You are guilty and could be charged. They have the definition in the bill here and there, but yet the definition has been selectively deleted throughout the new bill. There are proposed changes to offences and penalties in Section 37. These have been substantially increased, possibly to be as a deterrent. The employers are given the right to appeal the decision of the inspector, the Chief Inspector, in compliance with the Promotion of Administrative Justice Act. It's unlikely that this amendment bill will be signed by the President. We predict that there will be another amendment bill because this one is so badly written, so don't expect anything soon. If we looked at the draft bill, inspectors' powers to impose fines. By the way, the document refers to 37A when it should be 37B. It reads, an inspector may make a recommendation in writing, to the specialist inspector that a fine be imposed on an employer in terms of Section 37B. If an employer contravenes or fails to comply with any provisions of this Act, note, any provisions of this Act, and yet there is a schedule listing the causes of a fine to be imposed. So it's not just any provisions, only those in that schedule. Advocate Lurch highlights that an inspector can only recommend a fine and not impose a fine. Fines are regularly challenged, you know. These infamous prohibition notices. It would be irrational and disproportionate to shut down an entire work site when the threat to persons exists only in a portion of that site. You could sue the inspector personally, you know. A normal, regular inspector cannot impose a fine. Only a specialist inspector, and this is not in the amendment bill. An inspector cannot recommend a charge of culpable homicide for a fatal accident. Only the National Prosecuting Authority can. That's why the First Amendment will have another draft which must address these imperfections. Other parts of this Section 37 are also brought under scrutiny. So there we have some of the changes of what appears to be areas of concern. We will probably see another amendment in the future. Please note, though, that I'm not a lawyer and therefore assume no responsibility or liability for any errors or omissions in this video. The information contained in this video has been sourced from webinars featuring speakers discussing the same topic. This information is extracted on an as-is basis with no guarantees of completeness, accuracy, usefulness, or timeliness. But so, in the meantime, for your health and safety legislative training, legal compliance audits, management systems, or other health and safety information you may require, please feel free to contact me on 078 160 1994 or drop me an email on deline@worksafetysa.co.za. Stay safe now.